In making his findings, Judge Hilary Squires said the following words: "It would be flying in the face of common sense and ordinary human nature to think he did not realize the advantages to him of continuing to enjoy Jacob Zuma's goodwill to an even greater extent than before 1997. And even if nothing was ever said between them to establish the mutually beneficial symbiosis that the evidence shows existed, the circumstances of the commencement and the sustained continuation thereafter of these payments can only have generated a sense of obligation in the recipient, Jacob Zuma. If Zuma could not repay the money, how else could he do so than by providing the help of his name and political office, as and when it was asked, particularly in the field of government contracted work, which is what Sheikh was hoping to benefit from? And Sheikh must have foreseen, and by inference did foresee, that if he made these payments to Zuma, Zuma would respond in that way. It seems an inescapable conclusion that he embarked on this never-ending series of payments when he realized the extent of Zuma's indebtedness." Good evening, News24 subscribers and viewers. My name is Adriaan Basson. I'm the editor-in-chief of News24. And this judgment I've just read you a small excerpt from was delivered 16 years ago. Can you believe that? 16 years. I was sitting in the Durban High Court that day when the now late Judge Hilary Squires convicted Schabir Shaik, the former financial advisor to then MEC first Zuma, then Deputy President Jacob Zuma, later on President Jacob Zuma. And Shaik was, of course, sent to prison for a very short while before he made it onto the golf course, but that's a story for another day. I'm joined tonight around the editor's table by two wonderful and clever colleagues, Karyn Maughan, the News24 legal specialist writer. Good evening, Karyn. You have to unmute yourself. We want to.
I'm muted now. Okay, I'm ready. Hi.
And Mpumelelo Mkhabela, the former editor of the Sowetan, a News24 columnist and independent political analyst. Good evening, Mpumi.
Good morning, good evening.
Mpumelelo, can you remember where you were on that day when Schabir Shaik was convicted, but there was another name that was mentioned every time in relation to Shaik in that judgment, and that was Jacob Zuma?
I don't remember where exactly I was because that's a long time ago. And but I know for sure that I was not covering the trial. I was not a court reporter, but I was a political journalist, always observing the political ramifications of the trial and, of course, the judgment itself. And what I remember, though, however, is that shortly after that judgment, I remember I was in Parliament at the time. I was a political correspondent, and President Mbeki then convened a press conference and then said that based on what the judgment had said and the implications that it has for somebody who holds high office like Zuma as deputy president at the time, the judgment is of a nature that he would not allow Deputy President Zuma to continue in his position in cabinet. And then that sparked, of course, a series of political activities, and eventually culminating in Zuma calling a press conference at Steinhays. I remember attending that press conference, and Zuma delivering a message where he actually conceded that he had to step down. It was very somber a press conference, and I remember it appeared as though Zuma had lost weight in a very short period of time. And I remember writing a piece about his appearance at that press conference where he looked like his suit was hanging loosely on his body frame, and he looked very stressed. I had never seen Zuma like that. It was a very difficult situation for him. And that actually then began a process where Zuma mounted his own campaign to come back to politics.
Of course, and that gave us the ANC for the past decade. Karyn Maughan, Monday the day. We told our readers tonight, 16 years after Sheikh was convicted, will Jacob Zuma finally go to trial? Monday is supposed to be the starting date of the Zuma trial in the Pietermaritzburg High Court, but will it actually start? Because there's some other issues that still has to be sorted out.
Well, I mean, the big one, of course, is who's exactly is representing Jacob Zuma, and are they ready to run a trial that is going to be extremely forensically loaded, extremely detailed, and extremely well prosecuted by one of the people that is arguably one of the best prosecutors in South Africa, Billy Downer, who, of course, was the force behind the Schabir Shaik prosecution. We are, I understand that Tabani Masuku, who was one of the advocates who resigned as part of Zuma's legal team, last month because of undisclosed ethical issues, has now returned to the legal team and will be, as we understand it, bringing some form of application in relation to Billy Downer's presence in this case. We know that Billy Downer's handling of the case has been a substantial focus of Jacob Zuma's attack over the last decade or so. It was as well in the permanent stay of prosecution, in which he was unsuccessful. He abandoned certain allegations that he made about Billy Downer being quote unquote nostalgic for apartheid and personally biased against him, which his legal lawyers then sought to revive in the Constitutional Court, causing a massive level of friction and the ultimate firing of Daniel Mansha, the then attorney. But we do expect that potentially those kind of averments are going to be made again. And then what the court will do with that, under the leadership of Judge Piet Koen, who's a former acting SCA judge, remains to be seen. But the state is ready. The state has spent the last month in Pietermaritzburg, holed up in a hotel, preparing itself. This has been over 2 decades in the making. They are ready to lead evidence. Thales, the French arms company, who is Jacob Zuma's co-accused, is ready to run the trial. Barry Roux, of course, Oscar Pistorius's former advocate, very prepared, ready to run the case. The only variable here is Jacob Zuma's legal team, what remains of it, if it continues in its current structure, and what it does if it is indeed going to take this case on.
Karyn, so and I say this with the absolute greatest respect, and not intend to insult his legacy, but it does seem that the Stalingrad strategy did not go away with the passing of Advocate Kemp J. Kemp, who was Jacob Zuma's advocate and lawyer for many years, and who I definitely thought was the main architect of the Stalingrad strategy behind postponements. It does seem that Jacob Zuma himself may have something to do with this.
Well, I mean, at the time when Kemp J. Kemp was saying that, was in a courtroom in the Durban High Court, and he said, basically, we will fight them in every room, in every street, and every house, in a kind of reference to the Battle of Stalingrad that, defined World War II in many respects. And that has been a hallmark of Jacob Zuma's litigation legacy. Unfortunately, in many respects, Jacob Zuma built the bars for his own prison, because in adopting that approach, he essentially ensured that the mutual legal assistance requests through which those crucial documents from Mauritius, including the encrypted fax, the evidence against him was effectively rendered admissible. All the processes that would have gone on in a trial, he basically ensured, were kind of done before the trial runs. The search warrants that formed the basis of the, 93,000 pages of documentation that are now being used in the forensic audit into Jacob Zuma's financial affairs have all been admitted in evidence, thanks to eventually the Constitutional Court. Of course, that's also related to John Hlophe's current travails, but that's another story for another day. So there was this culture of state taxpayer funded litigation, which we now know amounts to about 25 million rand, in which Jacob Zuma was essentially able to litigate, as the Pretoria High Court put it, on an almost luxurious scale to almost push the trial further and further down the road. That has now come to an end. He has to pay back 25 million rand in legal fees,
which he doesn't have.
He doesn't have. He has no, his lawyers will not be paid. And he's sitting in a circumstance where he's effectively rendered some of the most damning evidence against him admissible before this court has even heard his the state's case against him.
We've got lots of ground to cover tonight in the remainder of this hour. And I definitely, Karyn, want to go back to Judge Piet Koen. You broke the story a few hours ago on News 24 that Judge Piet Koen will be the presiding officer. And as we've known from all high-profile cases, the judge becomes a central player in this trial. And inevitably, in a few months' time, if the trial starts, we will all know everything about Piet Koen, where he comes from, his weaknesses, his strengths, what he does on weekends, how many times he's been married, if at all. I want to come back to that. But Mpumelelo, just for a moment, take us back to the arms deal. I mean, this case centrally was still about the arms deal. If I remember well, the main evidence, or the first time the then Scorpion stumbled upon evidence implicating then Deputy President Jacob Zuma, was the French fax, which a woman called Sue Delique, who was a secretary at the South African affiliate of Thales, the French arms firm, one day resigned and took a lot of documents in a bag and handed this to the auditors, Arthur Anderson at the time, and it then was given to the Scorpions. And this confirmed the bribe that Zuma agreed to, allegedly, to receive from Thales. But Mpumelelo, this is 30 years ago. We almost go back 30 years ago. Why was the arms deal never properly dealt with? And do you think this is probably the last trial we will ever see that deals with that matter?
You know, Adriaan, one of the most interesting things about the arms deal is that actually it is nearly as old as our democracy itself. And what I find inexplicable is that before 1994, one of the major points of campaign for the ANC when it sought to attack the apartheid government was that the apartheid government was spending a lot of time on the military, basically to to torture people, to deny them of their rights, to kill them, to harass our neighboring countries, invade them, bomb, and do all kinds of disruptive activities. So the military was never going to be the fan of a new ANC government, which was going to divert a lot of whatever budget that it could find when it takes over to social causes, education, health, and all of those things that the apartheid government had denied the majority of the citizens of the country. But suddenly, the ANC takes over, it becomes a government, and then the priorities suddenly change. And now it becomes, we want to spend more money on arms than on any other thing. The second thing that's puzzling about it is that the arms deal coincided with the Mbeki government deciding in 1996 that it was going to adopt a policy called GEAR. Basically, the critics of that policy would call it a neoliberal policy, right-wing policy. But the essence of it was that the government will cut back on expenditure, right-size the civil service, and make sure that there's not much borrowing to improve the government's credit ratings. You know, it was like a fiscal prudence type of policy that was at the time very synonymous with the so-called Washington Consensus. So in the middle of all of that, cutting back social expenditure, cutting back expenditure on many other items, but there's one item that you are picking up and you want to spend more on it, which is the arms deal. So it really, until today, it never adequately made sense in light of ANC policy. So now that says something about what might have happened behind the scenes in the last days of the ANC as a party waiting to be in government. Who are these people that were lobbying the ANC to change its course insofar as acquisitions of ammunition and armaments is concerned? Now, the Zuma thing tells us something, that there might have been something where people were waiting for something, to get something out of a deal of that nature, because it all looked like, there was some people knew about it in advance and they kind of like lined themselves up. And Schabir Shaik, the swiftness with which he set up these companies, Kobe and all of them, lining them up to be BEE partners of this French arms dealers. It all looked like people knew that there was this thing that was coming and they needed to prepare themselves. And if you look at people like the involvement of people like Nyanda, the former head of the army, Siphiwe Nyanda, and then people like Tony Ngeni, and many other people. You remember there's a guy called Mashimbi. At some point, he was a committee member in Parliament of the Defense Committee. So a lot of people got involved in this. However, Jacob Zuma is the only person who, when it was investigated, it could be verified that actually in the process of contracting, he tried to say, listen here, I'm going to do this arms dealer a favor. Should there be any investigation about whatever suspicion, I'm going to help them. And Shabir Sheikh, who was also going to be the beneficiary, subcontracting and all of those activities, he chipped in there, paid Zuma a lot of money. Of course, money that we know also originated from the arms dealers. Now, it's clear that this is a combination of politics, policy, corruption, and a political party that somehow appeared to have been tripped in its last days, just before it got into government. And it got repurposed into prioritizing acquisition of armaments at the expense of other expenditures. So yes.
Sorry to interrupt you, but of course, many of those secrets in Mpumelelo died with Joe Modise, the Minister of Defense at the time, and some would argue the central figure in the arms deal.
We still have Fana Hlongwane. Fana Hlongwane is around.
Absolutely.
He was working with Joe Modise quite closely.
He survived all the years. He was working with the Guptas as well, right?
Yes.
Look, I want to ask you this, Mpumelelo. The arms deal, looking back now, we talk a lot about state capture now. We talk a lot about the Guptas and what we're hearing at Judge Zondo. But I think I've got a suspicion when we listen to the evidence in the Zuma trial, scheduled to start on Monday, Karyn, we will be telling ourselves and asking to ourselves, how did we miss this? How did we repeat the mistakes from 20 years ago again? Because corruption isn't new in the ANC. Corrupt BE deals isn't new. Comrades in business isn't new. We saw Tony Ngeni being convicted of fraud. Do you think there's going to be an element of that as well when this trial finally starts?
I'm really, this is another puzzling thing about the Jacob Zuma situation, because if you look at what's happening now with this, in fact, before the Guptas, if you look at what's happening with Bosasa, you wrote an excellent book about the corruption of Bosasa. If you look at what happened there, and you look at what happened with the Gupta state capture, it appeared to me it was like an elevation or the progression or the advancement of what Zuma had allegedly done earlier, 30 years ago, with Shabir Sheikh and the French arms dealers. The only difference, or the difference, is that in this case of the Bosasa and the case of the Guptas, there was a lot of sophistication around it, and the corruption that has been leveled against the players is so grand that it was not about chipping a pie somewhere of a slice of an arms deal. It was like taking over the whole country. So which says something about the fact the failure to punish the arms deal wrongdoing quite earlier on was, in my opinion, the path towards state capture that we see today.
Mpumelelo, just to maybe end this chapter, a quick anecdote. I don't know if you remember the name Tony Georgiades, but Tony Georgiades was a Greek businessman, an arms deal fixer, and he was one of those Fana Hlongwane characters who introduced the arms deal companies to the politicians. And what I always found very interesting and probably underreported story was that Tony Georgiades had a wife called Elita, who was then later had an affair with one F.W. de Klerk. And during that time, the clerks introduced Georgiades to one Thabo Mbeki. So there was an interesting link and almost a handing over of these connected figures with the European arms companies between the National Party handing over power to the ANC, and in the process, Jihadis also handed over his wife. But let's quickly move along to Monday, Karyn. I want to come back to you because we already heard from you now that the trial may actually not start. There's two things, it seems to me, that's going to have to be dealt with. Firstly, who's actually Jacob Zuma's lawyers, because his lawyers withdrew. And if I'm correct, Karyn, didn't the court ask his former lawyer to come and explain himself on why he withdrew? And just before you answer that question, may I remind all our subscribers who are part of this editor's table tonight that you can ask us questions. There's a Q&A button on your screen, or a chat room button. Hit it and type your question, and we will get our clever panelists to answer your question. And if you want to participate next time, if you're a viewer of this live stream, become a News24 subscriber, then you can also ask us questions. Karyn, over to you.
Yes, I mean, the Deputy Judge President of the KZN High Court has asked Eric Mabuza to come to court to explain the withdrawal at the last minute. Judges are, able to do that in these kind of circumstances, particularly given that, there seems to be at this point very little explanation for what exactly happened. Though we have seen some media like IOL claiming that there was an ethical issue that was raised that needs to be the Zuma's lawyers felt was insurmountable. Despite that, however, Tubani Masuku has returned to the team. So depending on what Eric Mabuza says, there could be repercussions for his presence there. And then, of course, the big issue, if new lawyers are brought in at this juncture, will they want additional time to prepare for the trial? And if so, how much time will they be given? Is there an intention to persist in this attack on Billy Downer being the prosecutor in this case, which I would very much venture is very unlikely to be successful? And if that application happens and fails, do the lawyers then seek to appeal it or delay the trial in respect of that appeal? I mean, all of this is very, very much up in the air. And given the kind of variables that are at play, the judge is really going to have to take control of what happens in that courtroom very, very early on.
What do we know about him? What do we know about Judge Pitkun?
Well, he did interview for a position at the Supreme Court of Appeal. He's a judge with 14 years of experience. He's fairly highly regarded within KwaZulu-Natal. He was given quite a hard time by Chief Justice Mogoeng, who felt affronted by him during a September 2016 meeting about judicial budget cuts, and felt the need to raise this during his interview, as he did with some other candidates who he felt had disrespected him. Couldn't handle that quite well. I mean, he was unsuccessful in being appointed to the SCA, but he did say, look, he'd read the transcript of the meeting, did not feel that he had been disrespectful. However, perception, was one thing, and that if he had created that impression, he certainly apologized and did not have any intention to do so, which was an apology that the Chief Justice accepted. I think that, I'm not sure what informed his selection, but he is very, very highly regarded. He has acted in the SCA not on several occasions, and I know that Judge President Meyer regards him very highly. So I think he's quite a stable, regarded as quite a stable judge. And obviously, one doesn't know how many other judges were approached before, he was, if he was the first choice, because I would hazard to guess that given the kind of aftermath that, for instance, Daya Pillay and others have faced after presiding over any kind of Zuma matter, and the way in which, unfortunately, because of the handling of the JSC, those kind of cases have proven to be career limiting for certain judges. I think it would take, a great deal of, a degree of courage to agree to do this.
Karyn, there's a question from an anonymous reader or viewer, shall I say. Karyn, don't you think a full bench for this case would have been better, considering that Judge Kuhn was perceived at the JC interviews as rude and discourteous? I'm anticipating this to be used against the Honorable Judge later on.
Yeah, I suspect that is correct. Look, it's very unusual to see. I mean, I don't know if I've ever seen a full bench here criminal case. Jackie Salibi's case was heard by Judge Mayor Jaffe. Typically, criminal cases don't have more than one judge, precisely because if there's an appeal, then it goes to a full bench or the SCA. We know that the permanent stay of prosecution was decided by a full bench of judges. But that was because of the fact that it was a civil application. The Charles Racketeering case was also a civil application. So I think that it might be seen as a bit unusual in those circumstances for a full bench to hear the case. A lot of the criminal cases have assessors.
Yes.
I'm not sure if that's going to happen in this particular matter. That's a number of the courts have done away with the assessor system because of budget cuts. But it may well be the case that given the overwhelming weight of evidence, because we are talking about forensic reports, we're talking about very detailed bank statements, phone records, all this kind of stuff, whether or not there will be assessors brought in because of the level of evidence that's going to be laid.
Karyn, another question for you from our subscriber, Peter Nadia. Can the judge rule against any subtle or blatant delaying tactics by the defense?
Well, the judge has to deal with every application as it comes. So, for example, if there is a challenge, an application to seek the recusal of Billy Downer, the judge will then hear it, preside over it, and make a determination. Does he give a full decision in that moment, or does he have the option to say, look, I will give my reasons at the end of the case. I don't believe that this is the correct, I don't believe there's grounds for a recusal, which in the normal criminal context would be something that would typically happen. But if there is a push to utilize any such application as a mechanism for delay, you may see a scenario when the Zuma's lawyers then say, well, we're going to bring an appeal, much like they did in the Zondo inquiry, where they said, well, we're going to seek a recusal of the judge, which they then failed to really do anything with, but used it as a mechanism to arguably badly attempt to justify his non-presence at the inquiry. The judge has to deal with every application as it comes. We exist in a constitutional democracy where the rights of the accused are held as very significant because of the kind of past that we come from. And the judge needs to tread very lightly. He needs to consider the applications and apply the law in a way that will sustain scrutiny further down the line, because it is almost certain that whatever happens here is going to be the subject to an appeal, and the record will be important. So he needs to show circumspection.
Mpumelelo, I want to ask this question. I want to address this question at you. So a reader, anonymous reader again, you guys are more than welcome to use your real names. We are very friendly at News 24, is asking, is Jacob Zuma still a political factor?
Yes, Jacob Zuma is a political factor. As things stand, there are people that are busy mobilizing to go and support him when he appears in court at the Maritzburg High Court. And although the crowds have kind of like dwindled over time in appearances, but they are still there nonetheless. And I'm thinking that now with the ANC being in a situation where there's this enforcement of the so-called step-aside rule, there are so many disgruntled people that might want to mobilize and be seen to be supporting Jacob Zuma so that they can identify themselves as a larger grouping or a political factor in the ANC politics. Because now Esma Hashule, I'm sure he will argue that he's being persecuted in much the same way as Zuma is being persecuted. Kalni House is most likely definitely going to be there. So there is still a grouping that supports Jacob Zuma, although it has declined over the years and its influence has also declined. So, but it's there nonetheless.
Mpumelelo, there's a very long question from our reader Nkosi Mapumulo, but I do want to read it to you because I do think we have to also address, some of these views. So Nkosi writes, a captured judiciary is more dangerous than a man wielding a gun in public. I hope President Jacob Zuma will be given a fair trial. It is worrying these days to expect a fair trial if you are politically aligned to the radical economic transformation faction. The judiciary might be captured already if rumors are true that some of their names appear in the CR17 bank statements. President Zuma deserves a fair trial, and I hope the state has sufficient evidence to back their investigation. I still believe that Zuma is being harassed for his political beliefs more than anything. Mbeki is tainted in this arms deal saga, but because he is in alliance with Ramaphosa, he is being protected. Does the state have a case against Jacob Zuma?
It's a very interesting question. I mean, obviously, this person appears to be very sympathetic to Zuma's position. And look, the state has collected tons and tons of documents of evidence and forensic reports by auditing firms, and all kinds of experts have looked at it, and then they've produced this evidence that they want to present in court, and they are convinced that there's a case. However, I mean, this issue of political conspiracy and the judiciary being captured, there has been no evidence that has been put on the table to substantiate that. And it's interesting that this stance taken by the viewer is not different from the stance taken by Zuma when Zuma was called upon to appear before the Constitutional Court to explain himself why he wanted to why he ran away from Zondo Commission. So where he was actually arguing that the entire judiciary is captured and the whole democratic project and the constitution has been hijacked, something to that effect. So people say these kinds of things about judges, but they don't substantiate it. So the most dangerous thing, actually, more than merely saying the judiciary has been captured, the most dangerous thing is to allege that the judiciary has been captured and then discredit it, and to the point where people can then defy court orders, as Zuma has done in the case of the Zondo matter. So that actually is a threat to democracy, to make allegations about judges that you can't substantiate and then discredit the judiciary, and then it loses moral authority in the republic, and then we're dead as a democracy.
Correct.
Strong words, Mpumelelo. Karyn, did you want to come in on that?
No, absolutely. I mean, first of all, Jacob Zuma has never disputed that he received the benefits and payments now estimated at 4.5 million rand from Shabir Shaik. The question in this case, much like in the rape matter, was what was his intention in receiving those payments? When Shabir Shaik was convicted, he was convicted on the basis of 4 instances in which Jacob Zuma used his office as a political role player to further advance Shabir Shaik's business interests. When the state presents its case on Monday, if that happens, it will show 28 such instances. That's what it said in its court papers. There were mechanisms of tax evasion. There were also, this, according to the state's case, an attempt to disguise the source of the Thales bribe through what appears to have been money laundering, and in that money ultimately used, ironically enough, to do renovations on Nkandla. And the state feels so strongly about this that it's pursuing a racketeering prosecution, an organized criminal enterprise, where they're saying essentially this entire Thales Zuma Shaik operation was intended to disguise corruption through money laundering, 9 years of tax evasion, taxes that weren't paid. It was a sophisticated criminal enterprise. In contrast, and we must remember, when the spy tapes emerged in 2009 and they were used to scrap the case against Jacob Zuma, wrongly and unlawfully so, as we now know from the decisions of the NPA itself and the SCA, there was never a contention from the state that the case against Jacob Zuma was not strong. And that was what formed the basis of the court saying, the timing of prosecution does not impact on the merits of the case against this person. And Jacob Zuma was very lucky because as president, he had huge access to untrammeled funds to litigate, and avoid his day in court. Not unlike what has happened in the state capture inquiry, where he has modeled the behavior of former apartheid leader P.W. Botha, who used language very similar to that utilized by Zuma to dismiss the TRC as a politically motivated witch hunt against him, which unfortunately sounds very eerily familiar in our current context. Unlike with that, the CR17 issue, there has been no substantive evidence that any judge was on that payroll. The EFF, which has been the source of some of these allegations, had full access to that bank statement and is very well aware that that is not the case. And hence, they did not attempt to pursue that argument when they argued for those records to be unsealed in court, because they know full well that it is not the case. If the public protector, Busisiwe Mkhwebane, had found any such evidence, I don't think for one moment she would have sat on it in that report, given the kind of far-reaching findings which were ultimately invalidated. So I think that, you know, when one interrogates the facts and the information that underpin both of these cases, it's very obvious that these attacks on the judiciary are unsubstantiated, baseless, and vague in a broad attempt to delegitimize them as they stand ready to make determinations on very, very politically loaded cases. And, you know, as Mpumi says, it is incredibly dangerous and damaging to democracy to effectively trying to judge, you know, to discredit courts of law before they can even make decisions.
Nkosi, as a final word from me, I would strongly recommend that you go and read the judgment by the Supreme Court of Appeal in Karyn, I think it was 2009, dismissing the judgment of Judge Chris Nicholson. It was written by the then Deputy President of the SCA, Louis Harams, and I've posted it in the chat group. If you just click on chat, there's a link by, Charlene, my colleague, so kindly posted it there. It's a link to the SAFLI website. Please go and read that judgment. It deals thoroughly and conclusively, I would argue, with the matter of political conspiracy against Jacob Zuma and how, if at all, it should impact on the criminal trial. Karyn, I want to stick with the topic of the charge sheet before we go to another question from a viewer. Let's just go back to the Schabir Shaik charge sheet and help explain to our viewers how that differs from the charge sheet or the indictment that will be served on Monday, will be read on Monday. So Schabir Shaik, if I remember well, was convicted of 2 charges of corruption. The one was about the arms deal bribe, and the second was about this bribery of Jacob Zuma, the systemic bribery, and then also a charge of fraud. What does the charge sheet look like for Zuma and Thales?
Well, remember that post the Schabir Shaik case, the Scorpions conducted a series of raids on the homes of and offices of Jacob Zuma and his lawyers. And, you know, while Schabir Shaik was charged in the region of paying Zuma, I think over about, you know, 1.2 million rand over a 10-year period, the charge sheet in relation to Zuma now, it talks about 4.5 million rand and payments that actually continued, as I remember correctly, while Shaik was actually on trial. And it's also a racketeering prosecution. Schabir Shaik wasn't charged with racketeering.
Yes, that's a big difference.
Yeah, that's a significant difference. And it obviously has very material consequences for Jacob Zuma, because unlike corruption, you know, a normal corruption case would carry a 15-year sentence. Racketeering carries a 25-year sentence. And it, you know, it's a lot more difficult to prove. But if the state succeeds in this, and we're seeing it already in some of the emerging state capture related prosecutions, the use of racketeering to deal with, you know, these corrupt enterprises that result as a consequence of state corruption between, you know, corrupt corporates and, you know, tender rigging and you know, the ANC kickback culture that has emerged. That could be game-changing in the prosecution of that kind of corruption. So the Zuma case, in many respects, could end up setting a standard for how these kind of cases are in fact pursued. I mean, I think what's going to be interesting is that, you know, Mpumi is right. This was the ANC, the arms deal was in many respects the ANC's original sin. But it was something that was never dealt with. And now, in the lights of the billions that we know have been, you know, whether it was Transnet, Eskom, 4.5 million rand looks like a very, very small amount of money. And, you know, like when you read the charge sheet, it's about how Schabir Shaik paid for everything from like a 10 rand car wash to Jacob Zuma's groceries, his kids' school fees. I mean, essentially it was a scenario where, you know, he was picking up the bill for like the most mundane and tiny expenses. But it was about a wider culture of patronage that then re-emerged in Bosasa, and, you know, re-emerged in a lot of the other cases, including with PRASA, including with, you know, a number of the other SOEs. So it looks like small beer, to quote Rob Rose, but it's about a pathology that was embedded and not dealt with at the time, and arguably continues to haunt our country.
Karyn, is there any chance that Jacob Zuma's lawyers, have you heard anything around this, that they would argue on Monday, whoever is his lawyers on Monday, we're still not sure. You mentioned Tabani Masuku, maybe one of them. That they may argue that this trial is really, you know, that there's no more fairness in this trial, that the state has had so many bites at the cherry, first Bulelani, Ngcuka, and Mpumelelo, and I want us to go back to that moment, because I do think we sometimes have short memories about what happened under the Mbeki regime. But, you know, first Bulelani, Ngcuka, and the Minister of Justice, Peniel Maduna, next to him, announced that there's a prima facie case, but there's not a winnable case. It was something, I think that was the quote. It's prima facie, but not winnable, even though that never made sense to me. Secondly, then Vusi Pikoli did charge him, but then Mokotedi Mshe dropped the charges again. I mean, could he make that argument now that, listen, you've had so many chances to charge me, you can't proceed now, or has that all been dealt with and we are just going to listen to the KPMG report and tons of other evidence?
He made that argument in the permanent stay of prosecution application. And I think, you know, in fairness to him, he should have been put on trial with Shabir Shaik. In fairness to this country, you should have been put on trial with Shabir Shaik.
Imagine where we would have been.
No, it would have been a totally different trajectory. A lot of what we are doing now as a country is trying to recover history that we lost over 2 decades ago and rectify bad and very unjustifiable decision like 2 decades after the fact. And Jacob Zuma is correct. He should have been put on trial with Shabir Shaik. That decision, while it's been defended at length by Bulelani Ngcuka, who said, you know, there was an apprehension about blood on the streets of South Africa, you know, potentially with the prosecution if it wasn't, you know, successful, or there would be these difficulties. I don't think that that's a sustainable argument in any profound sense. And I think that, you know, now all those years after the fact, trying to get back to that point where we were at right at the beginning, you know, has had enormously adverse consequences for the NPA. A crucial reason why the NPA is now trying to rebuild its credibility is because, you know, it was of that 2009 decision. And, you know, its failure, first of all, to pursue Zuma when it should have. And then in the face of the, you know, very obvious manipulations of Bulelani Ngcuka and Leonard McCarthy about timing, which had no application to the actual case.
But it was still stupid.
It was stupid, and it did enormous damage. And Mshe felt at the time, with Zuma about to be elected as president of the country to take office, that, you know, that this was so fatal to the case that it had to be scuppered. Of course, that was a decision which was profoundly legally flawed and was overturned 7 years later. But, you know, the NPA, I think, is still dealing with the legacy of that. And, you know, now in this court of law, it's going to have to go take us all back 2-3 decades ago and try and relive events that played out. You know, some of us, you know, a lot of people watching weren't even born then, and try and you know, take back.
You make us feel very old, Karyn. Mpumelelo, can I ask you? I want to maybe be a bit naughty. I know you and I both love history. Can I ask you a very short question? Did Thabo Mbeki give us Jacob Zuma?
Well, indeed, he did, but it was not his first choice. I think he had very little options, because if you remember the history of how Zuma was appointed deputy president of the country, the background was that Mbeki had wanted to appoint IFP leader Mangosuthu Buthelezi as deputy president of the country, because at the time the thinking was that we're still undergoing this process of reconciliation. There were still a lot of divisions. You still needed to unite the country. There were still a lot of elements in KZN and other places of people who think that, you know, they can form their own republic. So there was a need to show that actually you can work together with your adversaries. And Buthelezi, having been a critique of the ANC's armed struggle and the motivation for sanctions. So they wanted to bring him closer and work. In fact, he eventually actually served in cabinet, but not as a deputy president. But what happened then is that the KZN leadership of the ANC, they fought against that because it was expected to be a trade of positions between the ANC leading KZN and then Buthelezi being appointed a deputy president of the country. But then the ANC leadership of Spoon Ndebele in KZN objected to that because they wanted to lead KZN. So they didn't want that trade-off. So eventually that whole thing collapsed. However, I think that the way Mbeki handled the Zuma question once the Shabir Sheikh judgment came out, I don't think he calculated enough what Zuma could have done, because at the time Zuma got support from the SSCP and got support from COSATU. Yes. At the time, COSATU was a strong federation, not like what it is now.
And the Youth League.
And the Youth League was still organized, and the Women's League was still organized. And then on top of that, Mbeki was spending less and less time on ANC matters and on domestic political matters. He fired Zuma, and then he was all over the world doing UN, AU, all of those other things. And then Zuma was making the club.
I would argue that even a bigger mistake was the first one, not to try Zuma. And I mean, you were around at the time. You know, that was a political decision, right? By Bulelani Nguka, Peniel Maduna, and Thabo Mbeki. And we subsequently heard, I think, Karyn, it was through, if I'm not mistaken, through affidavits by Ajay Suklal, the former lawyer of Thales, that in fact money was offered to Jacob Zuma to say, just go away. Just go away. You know, we're not going to charge you, but this is the deal. You're not going to continue in politics if you go away.
No, it was actually Michael Hulley. He made that allegation. I think it was when the DA was attempting to challenge the spy tapes decision. And on page 462, he drops this nugget about Peniel Maduna and Thabo Mbeki offering Jacob Zuma, I think it was in the region of 30 million rand, to take a quiet life and essentially exit politics. But you are correct. I mean, nothing really ever came of it. And we know Michael Hulley is now long since exited the legal team. But that was an allegation, which I'll be interested to see if it resurfaces during this trial.
Look, colleagues, I think we can debate for the rest of the evening what should have been done and how that would have changed the course of history. Maybe a very interesting virtual history book on that. But let's quickly do some more questions from viewers before we call it a night. Karyn, I have a question from an anonymous viewer. Surely the ongoing saga of hiring and firing Zuma's lawyers is a further delaying tactic, as the only real reason for withdrawal could be that they won't get paid.
Well, they haven't been paid for the last 3 years. I think that, I understand Eric Mabuza may have got something in the region of about R500,000 for the entire period. So, and Muzi Sikhakhane has gone on record and said we basically, and so is Jacob Zuma saying it was essentially pro bono. But, you know, that is going to be a question that gets addressed to Eric Mabuza on Monday. Is like, why did this happen? Is this a fees issue? Those questions are going to be put to him, and we'll get a real sense of what happened to that relationship when he answers them. Does he then say, yes, this is a money thing, or does he disclose what this exact ethical problem is? And you know what informed them leaving. It's very clear the court wants answers on this, and it's going to be a question of how far he goes in giving those answers.
Linked to that, Karyn, is a question from Sydney K. Do you think the court has the practical option to not accept the withdrawal of Zuma's lawyers?
No. Why is that? You know, they're not legal aid lawyers. They're not, if they say, look, if they make an argument, for example, we have a clear ethical problem here. We don't, for whatever reasons, whether they disclose, we can't continue with this. the court could put itself in a very difficult situation in saying, but you must represent him. I mean, lawyers do have the ability to walk away from cases, and they often, in the sphere of fees, if they were to make an argument that this was a money thing, the court would have, you can't force people to represent clients for free. I think the real question for me is going to be, if there is this underlying ethical problem that Tabani Masuku agreed to and now has apparently overcome, what are the implications of that, not only for him, but for the lawyers that withdrew? I mean, I think Monday is going to be incredibly important. And I think it could well determine the future shape of this case.
Adriaan, just sorry to barge in.
Yes.
On an unrelated matter, however, I think that this explanation that Karyn is talking about, that Eric Mabuza is supposed to make before the High Court, might give us another perhaps indication of what happened in that Constitutional Court case that involves the Zondo Commission at the Concord. Because it's not clear whether Zuma's non-appearance in the Concord and his refusal to submit anything to the court was at the advice of Eric Mabuza and Sikakane or not.
That's
fascinating.
And the implications of the legal profession, if they can advise a client not to appear before a court, what would that mean? I'm very much interested if that explanation of Mabuza might give us some indication, directly or indirectly, of what might have happened in the Concord case.
Karyn and Mpumi, here's a question from Nico Stein. You can decide who takes it. Good evening and thanks for the panel. Thanks to the panel. Would the prosecution and the public not be better served by pursuing a single slam dunk criminal charge against Zuma and seeing him behind bars rather than a protracted 5 to 10 year trial, which potentially sees him a free man for the remainder of his life? Karyn?
I'll defer to Mpumi. Do you want to answer that?
Well, I could do it. I think we must be careful. Like, listen, the evidence against Zuma might be overwhelming, but it doesn't necessarily or automatically mean that he will be found guilty. There might be other things that might come at play. We don't know how he's going to play his defense. Sometimes it's not about whether the evidence is overwhelming against you. Sometimes other factors can come into play that the court might consider and maybe say, as Zuma has always said himself, that, listen, I got the payments, but you can't prove that they were bribes. These payments were not bribes. And then the court might say, well, the evidence to prove that these payments were bribes is too lean and not sufficient enough to convict. So we should be careful not to convict Zuma here. He still has to appear before the court. He still has to put his case. For me, the most important thing that will really tell me that this country's democracy is working is when Billy Downer stands up and presents the case. His first opening sentence to present, the fact that the case is now open, is being presented, for me, that would be the major achievement.
Karyn, if I'm not mistaken, if I remember well from the Sheikh trial, his opening lines was a Latin quote. Something to the effect, I'm not going to try and repeat the Latin, but it was something around the effect of, this is a tale about a man and arms. And then he proceeded to present to the court the very persuasive theory of a parallel system, the parallel tender system, of how the arms deal had a formal tender system, but how the parallel system worked in the background. It was quite impressive. And of course, we'll see many of that evidence again, Karyn, including the famous KPMG report.
Yes, I mean, that's going to be one of the most interesting aspects, because we know that the author of that report, Johan van der Walt, came under a lot of fire over producing a draft interim report on the so-called SARS rogue unit. And what's going to be fascinating is, because obviously the SARS rogue unit narrative was very much used against Zuma's political adversary, Pravin Gordhan. Ironically enough, will probably be one of the most significant levels of attack that he can mount on Johan van der Walt. But will he play it, given that, the rogue unit thing has been, such a significant grounds for his attack on Pravin Gordhan? So all, there's going to be so many things in this case that intermingle. And it's going to be profoundly interesting. And I think one of the more interesting things for me is this happening at the same time that we see the two judges in the arms deal inquiry case under considerable fire for ignoring manifest evidence produced by Swiss prosecutors, Swedish prosecutors, German prosecutors, British prosecutors around the manifest fraud that occurred in the arms deal generally, implicating Johan Bredekamp, implicating Johan Afana Tlongwana, and also, these question marks about Thabo Mbeki. Jacob Zuma has always said, that he was, that he has been scapegoated for the arms deal. Is he going to use this as an opportunity to really lay bare why he says that is the case? And, do what he's always promised to do, which is name names? Or is he going to simply, embark on a series of legal or technical defenses and ultimately avoid the degree of his own culpability? Because ultimately this case is going to be about him, the onus is really going to be very strongly on him to explain a lot of the things that he did and get into the dock and respond to these cases, because it's clear he got money. It's clear he received benefits. And it's really about him saying, this wasn't for corruption. This was because this was my good friend and I was trying to assist BEE. This was an ANC policy, which is said in the past. And, whether he says those things persuasively enough to persuade a court that what he did wasn't corruption.
The million-dollar question is, of course, also, Karyn, will Schabir Shaik make his appearance in this trial as a witness on either side?
The state will never call him because his credibility has been completely destroyed. But it's, one doesn't know with the defense whether or not they will choose to call him, because he's always maintained there was a completely innocent explanation and that Jacob Zuma has been unfairly targeted. But I mean, if they put him in the witness box, they put him in the sight of Billy Downer. And
Take two.
I don't think that's something that anyone wants.
And of course, he will have to take time out from his golf, a break from his golf
Criminal
playing.
illness, yeah.
But he
Karyn Maughan,
Schabir Shaik remains aggrieved as well. He's not happy with Jacob Zuma.
yes.
Because he believed he should have been given complete pardon.
Exactly.
The Guptas became the Sheikhs after the Sheikhs went to prison. Karyn Maughan, good luck for Monday. You are going to Pietermaritzburg for News 24. Karyn will be writing every day for our subscribers from Pietermaritzburg High Court, analyzing and writing that one piece that you must simply read to understand what's going on in the trial. Mpumelelo Mkhabela, thank you so much. Looking forward to your column next week after the first few days of this epic trial we've been looking forward to. To all our readers and viewers, thank you so much for supporting News 24, for subscribers, for reading our journalism, and for listening to us tonight. See you again next week. Goodbye.
Yay.